Last one, let us know. 970. Welcome everyone. So we are at the last phase of our discussion of RTFQ, and by this time your examinations are also near. So we thought to cover the whole constitution from the point of Bare Act, as we have already discussed. And herein we'll be covering the questions from question number 416, and then we'll go on to 500. So these are basically questions from Bare Act. Bare Act means that your original constitution, you will find at some point of time that there are questions directly coming from these Bare Acts. Questions are not too tough with an intention that now exams are near, not to panic you. These questions will simply serve as a purpose of revision so that you are able to revise. And if you do not have the time to go through the Bare Act, you will be covering that, right? So let's start with question number 417. 417. The question says we'll be covering directly from Article 1 and then we'll try to go till the last. और वहाँ पे जितना questions cover होगा, we'll try to cover. And about the handout, by now, I think you people would have got your handout in the Telegram group. And also, as I've already told, that you will be getting a combined handout for all the RTFQs from 1 to 500, what we have covered. So by tomorrow evening, you will also be getting these handouts, including all the files, all these 9 handouts in together at one place, so that you can quickly glance through those and revise it, right? So let's start with question number 417. That says the names of state of Indian Union are specified under the first schedules of Indian Constitution. So names of states of Indian Union are specified, and it contains only the names of state and not of the union territories. Options as usual: 1, 2, both, neither. 1 only is the correct, because the names of states as well as the UTs. So under the schedule 1 of the Indian Constitution, we have the names of the states and we have the names of the UTs also. So here the answer shall be 1 only, because it contains also the union territories, right? So move on to question number 418. Consider the following statements. A bill contemplating the change in the names of a union territory needs to be sent to the respective legislature for their recommendation. Second, a law making changes to the first or the fourth schedule of the Constitution enacted under Article 3 of the Constitution shall not be deemed to be amendment to the Constitution, right? So these are the two statements. These are the two statements in front of us. First is saying that a bill contemplating a change in the name of union territory. तो क्या यूनियन टेरिटरी के नाम का जो चेंज होने वाला है वो उसकी लेजिस्लेचर को भेजा जाएगा? Not required, because union territories are under the direct control of the union, and for that matter only 2 union territories have the legislature. So even then it is not required, right? Secondly, any law making changes to the first or fourth schedule. अब क्या है कि हमने अभी देखा that our first schedule contains the names of all the state. So if you are going to change the names or split the state into 2 or 3 or 4, or you are going to merge the states, so this will have the ancillary change in the first or the fourth schedule. Fourth schedule relates to allocation of seats in the Rajya Sabha, right? So it will have change, but otherwise also, even though it is going to have certain changes in the first and fourth schedule, that will be bound to happen, but these changes will not be considered as an amendment, क्योंकि ऐसा स्पेसिफिकली आर्टिकल 4 में लिखा है कि स्टेट के चेंज होने से even if there is any changes in first or fourth schedule of the Constitution, that will not be considered as an amendment to the Constitution under Article 368, right? So this statement is true and this statement shall be false. So our answer shall be B only, right? You would be seeing that questions are not too difficult, simply giving you just a kind of a memory boost so that you can recall those provisions. Now, this is a question related to citizenship. Which of the following statement is correct? You have to find persons who migrated to Pakistan under a permit of settlement and acquired the citizenship there were also allowed to continue with the citizenship of India. This will be false statement. Article 9 says any persons who acquire the citizenship, his Indian citizenship shall be forfeited, right? both parliament and state legislature have the power to enact on the matters related to citizenship, naturalization and aliens. This is also false, because this citizenship, naturalization, these are the part of union list, right? These citizenship, naturalization and aliens, these are the part of union list, and also this is the power which is given to parliament under article 11 of the constitution to make laws related to the citizenship. At the commencement of the constitution, every person who has his domicile in the territory of India and who was born in the territory of India was granted the citizenship. Every person who had the domicile, right, and was born in India, so these two qualifications, whosoever fulfilled, they got the citizenship. This is true, and the provision is written under Article 5 of the Constitution. Once a person is granted the citizenship by the Constitution, it cannot be taken away. It can be taken away as per the law which is made by the Parliament, right? So there is this article 10 of the Constitution, that says that once a person is granted the citizenship, he shall continue to be the citizen of India. ऐसा नहीं कि उनसे छीन लिया जाएगा. However, if the Parliament by law provides that, his citizenship can be taken away, right? So this statement will also be false. Correct जो है हमारा क्या है? C. Moving on. Question number 420. Question number 420. That says, consider the following statements. Under Article 13, the word includes law, includes any ordinance, order, bylaws, rules, regulation or notification, but does not include any customs. If the statement makes any such violating, if the state makes any such violating fundamental rights, state makes any such law, so law is omitted here. If a state makes any such law violating the fundamental rights given under Part 3, such law should be held void in toto. In toto means in total, right? So this provision is related to Article 13. Let me quickly give a recap. So Article 13 contains 2-3 provision. One, it forbids the state from, meaning the Parliament, from making any law which is going to abridge the fundamental rights, right? So in this situation, there will be two things. One, that there is a pre-constitution law and that is now conflicting with the fundamental right, or there may be another situation after making of the constitution, Parliament enacts a law which is violating the fundamental rights, right? So constitution बनने से पहले जो कानून हमारे यहाँ देश में था, that was already there. Till that time there was no constitution. So what about those laws? So Article 13 gives an option that those laws can be rectified and brought in line, brought in sync with the provisions of the fundamental right. What about after 1950, when our constitution got in force? So there is a clear ban upon the legislature to enact any laws, which is abrogating any of the fundamental right. तो पहले की law की तो कोई बात नहीं. However, those law needs to be corrected. Otherwise, that will be declared void by the Supreme Court of India or other courts of India, whosoever is competent. But there is a complete ban on the state. State shall not enact any laws. तो complete ban है. अगर state वैसा कोई law बनाती है, that will be declared void ab initio. शुरू से ही गलत मान लिया जाएगा, right? But question ये क्या कहता है कि क्या वैसे पूरे law को in total, if any of the provision, let's say if the law has 100 provisions and out of that 5 provision is violating the fundamental rights, so should all the provisions be declared void? So it will not be that. Only the Article 13 says that up to an extent of repugnancy or up to the extent of inconsistency. So as much the portion is inconsistent with the fundamental rights, सिर्फ उतना ही void declare किया जाएगा, right? So this statement is false, right? This statement is false. अब उसके बाद क्या करता है Article 13? Article 13 ये भी define करता है that what is law. Law का meaning क्या है? And law में क्या क्या included होगा? So technically a law is one which is passed by the Parliament. But you will find that there are various occasions that laws are also made by the executive, such as ordinance is a law, is a kind of law which is passed by the President of India or the governors who are the part of the executive. Then order, bylaws, regulations, you might have heard about the SEBI regulations, RBI regulations. So these are the laws which are made by the executive. So क्या Article 13 के अंदर law का मतलब सिर्फ law made by Parliament है, or does it include anything else? So it includes all these things. The law includes ordinance, order, bylaws, rules, regulation, notifications, and it also includes the word custom. Law में custom भी जो word है, that is included. So customs which are governing your life in so much as the other laws are. So ऐसे customs, however, those customs are not in violation of any law. आपके religion के कुछ customs हो सकते हैं. For example, let's consider sati was someone's custom, but that is in now violation with our rights, and it is also in violation of Sati Abolition Act. तो ऐसा custom valid नहीं होगा. But all those customs which are governing the life of the citizens of India, but still it is not invalid because it is not violating any of the laws, those shall also be treated as law within the meaning of Article 13. राइट, तो लॉ को एक बहुत बड़ा डिफिनेशन दिया गया है. इट इंक्लूड्स वेरियस थिंग विच इंक्लूड्स ऑर्डिनेंस, ऑर्डर, बाईलॉज, रूल्स, रेगुलेशन. इतनी चीजें तो आप गेस कर सकते हो. कस्टम्स में आप कंफ्यूज हो सकते थे, बट यू शुड नो दैट कस्टम्स आर आल्सो ट्रीटेड एज लॉ विद इन द मीनिंग ऑफ आर्टिकल 13. राइट, सो हियर बोथ द स्टेटमेंट शैल बी फॉल्स, क्योंकि लॉ का मतलब कस्टम भी होता है. नॉट ऑल द प्रोविजंस ऑफ द law which is violating fundamental rights should be declared void, but only those provisions which are abrogating fundamental right, those shall be declared void. Right, so answer shall be D, because both of these statements are incorrect. हाँ, doctrine of eclipse is second statement. Doctrine of eclipse means, doctrine of eclipse article 13 से आता है. उसका मतलब क्या है कि if there is any law, right, which is violating the fundamental right, ठीक है. Now, doctrine of eclipse, first thing you should know that it applies only to the pre-constitutional laws, not to the post-constitutional laws. So, pre-constitutional laws में एक जो law था वो 1950 से पहले exist कर रहा है, and then in 1950 our fundamental right came. So now this law, if it is violating the fundamental right, this will be eclipsed by our fundamental right. And if Parliament removes those default, it will again come back to life. Or if fundamental right is itself not there, then these laws shall be alive. But 1950 के बाद तो कॉन्स्टिट्यूशन ने साफ मना कर दिया है स्टेट को कि आप ऐसे कोई लॉ बना ही नहीं सकते. तो सवाल ही नहीं होता है कि देयर विल बी एक्लिप्स फॉर पोस्ट कॉन्स्टिट्यूशनल लॉज. फॉर प्री कॉन्स्टिट्यूशनल लॉज दिस डॉक्ट्रिन शैल अप्लाई. डॉक्ट्रिन ऑफ एक्लिप्स इज द पार्ट ऑफ आर्टिकल 13 itself. Right, moving on to question number 421. Consider the following statements. Provisions enabling a state for making any special provisions for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and the scheduled tribes were added by the First Amendment Act. Second says the state is also empowered to make special provisions for admission of socially and educationally backward classes, scheduled caste or scheduled tribes in educational institutions including private institution and minority institutions. दो स्टेटमेंट है. पहला कि ये जो प्रोविजन है वो किस अमेंडमेंट के थ्रू आया और किस तरह के इंस्टीट्यूशंस पे अप्लाई होता है. इट इज क्वाइट ऑब्वियस दैट यू विल बी नोइंग दैट गवर्नमेंट इंस्टीट्यूशंस पे तो सब अप्लाई होंगे, बट व्हाट अबाउट द प्राइवेट इंस्टीट्यूशन? क्या प्राइवेट इंस्टीट्यूशन पे अप्लाई होता है? क्या माइनॉरिटी इंस्टीट्यूशन पे अप्लाई होता है? राइट, तो यहाँ पे लेट्स कंसिडर दीज स्टेटमेंट्स वन बाय वन. सो इट वाज इंट्रोड्यूस्ड बाय द फर्स्ट अमेंडमेंट एक्ट. दिस इज ट्रू, इसमें कोई दो राय नहीं है. इसके ऊपर केस भी था, राइट, 1951 में. But thereafter, in the second statement, it says the provisions related to admission of scheduled caste, scheduled tribes or SCBCs, it shall apply to the private institution, but it shall not apply to the minority institution. Minority institution के ऊपर नहीं लागू होगा, but private institutions में इनको enforce किया जा सकता है. This is mentioned in the Article 15 itself. It is not compulsory. But minority institutions पे गवर्नमेंट अपने रिजर्वेशंस के कोई प्रोविजन नहीं इन्फोर्स करा सकते. राइट, सो दिस स्टेटमेंट शैल बी फॉल्स. राइट, जो हमारा 421 है उसका आंसर होगा ए, वन ओनली. अगेन द क्वेश्चन इज फ्रॉम द रिजर्वेशन इटसेल्फ. EWS was quite in news, so let's see अगर एक क्वेश्चन आ जाएगा तो we have already run 2-3 questions and 2-3 आज भी हैं. So reservation to economically weaker section in admission to educational institutions may be lower than 10%. May be lower than 10% or may be higher than 10% या फिर 10% ही है, ऐसा कुछ. तो जो प्रोविजन है अंडर और कॉन्स्टिट्यूशन, इट इज फिक्स दैट देयर इज अ कैप ऑफ 10%. Constitution right maximum of 10% reservation can be there for EWS for admission into educational institutions. This means it can be lower. In some state, it is lower than 10%. So this is a true statement. The determination of EWS can be done on the basis of family income and other indicators of income disadvantages. Right? So किसी भी कोई भी person who are claiming this reservation, whether they falls under the EWS category or not, it shall be done after calculation of their family income. The present limit, as you call it, is 8 lakh rupees and per annum, of course, 8 lakh rupees per annum, and other economic indicators like holding of a residential property, etc. तो ऐसे कई सारे प्रोविजंस हैं जिसके बेसिस पे EWS स्टेटस डिफाइन किया जा सकता है. सो इट मे चेंज एज पर द रूल्स ऑफ द गवर्नमेंट, राइट. सो हियर 422 बोथ स्टेटमेंट्स आर correct, क्योंकि रिजर्वेशन इन EWS is capped for maximum of 10%. It can be lesser than 10%, but it cannot be beyond 10%. It cannot be beyond 10%, right? Question number 423. The provisions of reservation in promotions was included under Article 16 by Constitution 77th Amendment Act 1995. See, there are various kinds of reservation which is prescribed under our Indian Constitution. One is reservation to educational institution. Then there is a reservation in jobs of public appointment. And then there is reservation in promotion. Right? तो ये तीनों तरीके की रिजर्वेशन मिलती है, बट नॉट टू ऑल क्लासेस. रिजर्वेशन इज इन प्रमोशन इज नॉट एप्लीकेबल टू एससीबीसी, दिस इज ओबीसीज, and then it is not even applicable to EWS person, right? Those are only applicable to scheduled caste and scheduled tribes, and this reservation in promotion is there itself in under Article 16, right? The second statement says M. Nagaraj and others versus Union of India. This is a particular case, and court has held that if a state wish to exercise this power, firstly you should know that it is not mandatory upon the state to provide reservation in the promotions. However, it is mandatory for the jobs, for the educational institution. But अगर state चाहे तो अपने यहाँ जितने भी jobs है उसमें promotion में भी reservation दे सकता है, right? But if state want to apply this provision of giving reservation in the promotions, it should substantiate that this is a quantifiable data and this caste is underrepresented in that service. So if state is able to prove that with the quantifiable data, that there is inadequacy in representation in the favor of a particular class in that public employment, right, then this provision can be applied. This was the judgment of the Supreme Court under M. Nagaraj versus Union of India, right? So here 423, both the statements shall be correct. 423, both the statements shall be correct. Reservation in promotions was included 77th Amendment Act 1995, and then this case of 2006 had a validity to this rule, but it says that state will have to prove it with the quantifiable data. Now this is yet a simple question under 424. So it is asking about, this question is basically related to Article 19. So Article 19 में जितने भी freedoms हमें मिले हुए हैं, किस freedom पे कौन सा restrictions लगा हुआ है, so which of these are correctly matched, we'll have to find. On one side we have rights, other sides we have reasonable restrictions put upon. So which of these pairs are correctly matched, we have to find. Freedom of speech and expression, it can be restricted on the grounds of interest of scheduled tribes. Peaceful assembly, can it be restricted on the grounds of sovereignty and integrity? Forming associations, can it be restricted on the grounds of morality? To practice any profession, can it be restricted upon the ground of contempt of court? No. 2 and 3 only, right? So peaceful assembly can be restricted on the grounds of sovereignty and integrity. Forming associations, so you cannot form association for any immoral purpose. So upon your freedom of forming associations or union, it can be restricted on the ground of morality. Practice profession, it cannot be restricted upon the ground of contempt of court. However, freedom of speech and expression can be restricted upon the ground of contempt of court. In the interest of SCs, in the interest of scheduled tribes and the general public, the freedom of movement can be curtailed. Freedom of movement, Article 19(1)(d), उसके ऊपर interest of scheduled tribes का लगा हुआ है. So our option here shall be B. ये दोनों सही है. First and fourth are not correctly matched. Moving on, question number 425. First says Parliament may by law prescribe the circumstances under which and the classes or class of cases in which a person may be detained for a period longer than 3 months. So this provision, firstly let me tell you, it is talking about Article 22. So Article 22 prescribes about preventive detention. It generally gives you certain rights during the arrest. So प्रिवेंटिव डिटेंशन के बारे में फंडामेंटल राइट चैप्टर में डालने की कोई जरूरत थी नहीं, तो वहां पे हमने क्या लिखा है, राइट्स विच इज अवेलेबल टू अ पर्सन ड्यूरिंग अरेस्ट. सो अरेस्ट होते समय every person has got certain rights: right to be informed about those grounds upon which he is arrested, right to be produced within 24 hours before nearest magistrate. So ये right during the arrest है, but ये जो persons के right है, it is not applicable to those persons who are arrested on the grounds of preventive detention, right? So उसी preventive detention के बारे में ये question कह रहा है कि पार्लियामेंट जो है can firstly a person who is arrested under the preventive detention can be detained for a period of 3 months without being produced before the magistrate. Now उसके बाद से स्टेटमेंट स्टार्ट होता है कि क्या कभी ऐसा केस होगा जिसमें पार्लियामेंट कैन प्रेस्क्राइब दैट द पर्सन मे बी डिटेन्ड इवन बियॉन्ड अ पीरियड ऑफ 3 months, राइट, विदाउट ऑब्टेनिंग द प्रायर ओपिनियन ऑफ एन एडवाइजरी बोर्ड. तो रूल क्या कहता है कि अगर 3 महीने से ज्यादा किसी को डिटेन करना है तो 3 महीने के पहले, जब तक वो 3 महीने का पीरियड खत्म होता है, so before expiration of that period of 3 months, an advisory board is to be constituted, and that advisory board will further recommend that his or her extension can be extended beyond 3 months or not, right? तो ये पार्लियामेंट के पास क्या ऐसी पावर है कि वैसे किसी केसेस के लिए ऐसा रूल बना सके पार्लियामेंट कि यहां पे 3 महीने से ज्यादा भी डिटेन किया जा सकता है. सेकेंड क्वेश्चन सेज द बोर्ड रेफर्ड above, this advisory board shall consist of a chairman and not less than 2 members, and chairman shall be serving judge of the appropriate high court, and other members shall be serving or retired judge of any high court, right? Question number 4 to 5. 4 to 5 यहां पे देखिए सेकेंड प्रोविजन जो है, it is provision which is correct. It was inserted by 44th Amendment Act. However, this is not a valid provision because 44th Amendment Act का ये provision has never been come into effect, right? तो ऐसा कोई बोर्ड कॉन्स्टिट्यूट करना जहां पे एक उसका मेंबर जज होना चाहिए, दूसरा मेंबर जो अदर मेंबर सेल में भी जज, सर्विंग जज और रिटायर्ड जज, ये वाला जो प्रोविजन है ये अभी इफेक्ट में आया नहीं है, ये अभी इफेक्ट में आया नहीं है. दिस मीन्स दिस स्टेटमेंट विल बी फॉल्स. हाउएवर कोशिश की गई थी 44th अमेंडमेंट एक्ट में इस प्रोविजन को डालने के लिए, एंड इन 44th अमेंडमेंट एक्ट ऐसा लिखा गया था कि दिस प्रोविजन शैल कम इनटू इफेक्ट फ्रॉम सच डे इट इज नोटिफाइड बाय द गवर्नमेंट. बट जो गवर्नमेंट इस अमेंडमेंट को लेके आई वो गवर्नमेंट कोलैप्स कर गई और उसके बाद कोई गवर्नमेंट इसको कंटिन्यू कराई नहीं. सो दिस प्रोविजन विल बी फॉल्स क्योंकि ये इफेक्ट में नहीं है. फर्स्ट प्रोविजन सेज कि क्या पार्लियामेंट ऐसा कोई सिचुएशंस, ऐसे कोई केसेस के बारे में लॉ बना सकता है वेयर person can be detained even beyond a period of 3 months. So this is the preventive detention is under the legislative domain of the parliament. Parliament can create such laws. This will be a true statement. तो पहला वाला जो है वो statement true है. Second statement false हो जाएगा because this provisions however was tried to get enforced but it has never been implemented. 44th Amendment Act के थ्रू इसकी कोशिश की गई थी. आंसर है हमारा A. Moving on, question number 4 to 6. Consider the following statement. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. Second, the state is empowered to impose compulsory services for the public purposes. तो ये right against exploitation की बात कर रहा है, आर्टिकल 24 में है about the child labor. So prohibition of child labor, it is given under article 24 of the constitution. So it says, first provision says no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. This statement is true, right? But अगर आप एक और आर्टिकल देखोगे in this particular, so we have one thing that article 23 that says no person shall be human trafficking and forced labor, begar. So begar is a labor without pay, right? Begar. So this is a labor without pay. अब इसमें एक एक्सेप्शन है, सपोज दैट फॉर एनी अदर पर्पस, मान लो you must have heard about certain countries where military training or serving in military for 1 or 2 years is mandatory, right? So एक ऐसा एक्सेप्शन हमारे कॉन्स्टिट्यूशन में भी आर्टिकल 23 में डाला हुआ है, that if state want they can engage the persons or the citizens of India for compulsory service for public purposes. तो क्या ये बेगार है? Should it be considered as begar and should it be stopped under Article 23? So no, Article 23 generally says that there will be a prohibition on the human trafficking and there will be a prohibition on the begar, that is free labor or forced labor. But such labor which a person does for the state in order in public purposes, that is compulsory service, that will not be considered as a begar, right? So here both the statement will be true. Firstly, there is a ban on the child labor, and secondly, state is empowered to impose compulsory services for public purpose, right? Answer shall be C. Both the statements are correct. Consider the following statements 4 to 7. The Constitution of India has nowhere forbidden discrimination on the basis of class. Rather, it forbids discrimination on the basis of caste. पहला स्टेटमेंट ध्यान से पढ़िएगा. The Constitution of India has nowhere forbidden discrimination on the basis of class. Rather, forbids the discrimination on the basis of caste. Right? अब देखो, आपने आर्टिकल 15 पढ़ा होगा. So it says, no one shall be discriminated only on the grounds of race, religion, caste, sex, place of birth. 16 में भी. Then you have Article 29, that is, state shall not discriminate on the basis of religion. Then you have Article 325, no one shall be excluded from the voter list on the basis of race, religion, caste. But there is one article, Article 23 itself. वो क्या कहता है कि स्टेट, आपको ये समझने के लिए थोड़ा ऊपर जाओ, ये प्रोविजन, द स्टेट इज एम्पावर्ड टू इंपोज कंपल्सरी सर्विस फॉर पब्लिक पर्पसेस. अब इसके आगे क्या लिखता है कि while making those compulsory services, states shall not discriminate on the basis of caste or class. So there is one article which is also forbidding discrimination on the basis of class, and that is with regard to compulsory services. This is under right against exploitation. ठीक है? So there is one article. तो ऐसा बिल्कुल भी नहीं है कि at nowhere. So state, there is a restriction on the state to discriminate on the basis of class as well, and caste के लिए तो बहुत जगह आप देखते ही होंगे, right? It has empowered the state to make, it has empowered, Constitution has empowered the state to make special provision for women and children. This is quite easy to understand. This is under Article 15(3), right? So first statement here is false. The first statement here is false. The second is true, right? So our answer shall be B. Moving on to 428, consider the following statements. Individual freedom of conscience can be restricted on the grounds of public order, morality and health. This is talking about Article 25. So Article 25 says every person subject to public order, morality and health shall have the right to practice, propagate, profess freedom of conscience. तो ये आर्टिकल 25 में आपको राइट मिली है, बट दैट राइट इज नॉट एब्सोल्यूट. इट कैन बी रिस्ट्रिक्टेड ऑन द ग्राउंड्स ऑफ these things, public order, morality and health. Now second statement says wearing and carrying of kirpans is deemed to be included in the profession of Sikh religion. It is deemed and it is mentioned in the constitution itself. कुछ टाइम पहले हिजाब वाली कंट्रोवर्सी हो रही थी, तो वैसा कोई मेंशन कॉन्स्टिट्यूशन में हिजाब के लिए नहीं देखा है, बट दिस आर्टिकल इटसेल्फ mentions about wearing and carrying of kirpans is considered to be the part of Sikh religion itself, right? So this statement shall be correct, right? So this is true, answer shall be C. Both of these are correct. Again, upon the right to religion, consider the following statements. Article 25 prescribes individual right to religion, while Article 26 provides collective right. This is true. So Article 25 gives every one of us the freedom of religion, conscience, practice, propagate. Article 26 gives the religious denomination the right to control property, move, acquire property, dispose property. So but there is a distinction it is asking. Unlike Article 25, the collective right provided under 26 cannot be restricted on the ground of public order, morality and health. Article 25 में तो हमने देखा it can be restricted on the grounds of public order. Can Article 26 also be restricted? Yes, it can also be restricted. So both Article 25 and 26 can be restricted upon the grounds of public order, morality and health. So this statement will be false. First one is true. Answer shall be A. Consider the following statements. Both Parliament and state legislature are empowered to enact for the punishments for the practice of untouchability which has been abolished under Article 70. Only Parliament. Only Parliament. So it is only the power of Parliament, not the state legislature. Right? Both Parliament and state legislature can prescribe residence as a requirement in regard to class or classes of employment or appointment of an office under the government of any state or local authority within a state or union territory. Both Parliament and legislature of the state. Only Parliament. This is given under Article 16. पहले states अपने अपने रिजर्वेशन लगाती थी, but there is an act which is made by Parliament which has put a stop to all those kinds of reservation. रेजिडेंस बेस्ड रिजर्वेशन की एमपी में सिर्फ एमपी वाले जाएंगे, केरला में सिर्फ केरला वाले जाएंगे, आंध्र प्रदेश के लिए सिर्फ आंध्र प्रदेश के रेसिडेंट अप्लाई कर सकते. हाँ राइट. तो उसमें क्या है कि देयर इज वन एक्सेप्शन दैट लैंग्वेज कैन बी प्रेस्क्राइब्ड एज वन क्राइटेरिया. दिस इज फर्स्ट थिंग, नॉलेज ऑफ लैंग्वेज, लोकल लैंग्वेज. एंड ऑल्सो these restrictions is available on class A and class B jobs. Class A and class B jobs में residence based reservation has been abolished. It is applicable in class C, D jobs because there you need to work upon the local level. There is a direct public dealing. So residence and the requirement of residence in that particular state becomes very essential for the fulfillment of their duty. But it is the Parliament who has the power to make law regarding all those residence-based reservation. It is not the legislature of the state. This is specifically mentioned under Article 16 itself, right? ठीक है? तो question 430 का both the statement is false. Answer is D. Now these are the questions about DPSP 431. Which of the following has been added to Indian Constitution by 42nd Amendment Act 1976? So इसी तरह के क्वेश्चन यूपीएससी आई थिंक 2017 या 18 में भी पूछ चुकी है, but the options are slightly different, right? But they had asked the question about which of these are added by 42nd Amendment Act. So equal aid and free legal aid, equal justice and free legal aid under Article 39A, protection and improvement of environment, safeguarding of forest and wildlife, 48A, Organization of Agriculture and Husbandry, Part 4A of the Indian Constitution, that is Fundamental Duties. So इनमें से कौन से हैं जो 42nd Amendment Acts के थ्रू आए हैं? Part 4A, that is 42nd Amendment Act. Fundamental Duties जो आई हैं ये भी 42nd Amendment Act के बाद ही आई हैं, and that too after the recommendation of Swaran Singh Committee. So initially there were 10 fundamental duties which were added by 42nd Amendment Act. The 11th one was added by 86th Amendment with right to education. Right to education 86th Amendment Act के through आया है, and that made the change in fundamental rights, DPSP and fundamental duties also. So this 11th fundamental duty is related to the persons that they should create an environment, or it is their duty to educate the children from 6 to 14 years of age, right? So here this is also added by, this is also added by, this is also added by 42nd Amendment. This was there in the original Constitution of India, right? So answer shall be B, 1, 2 and 4. Which of the following is or are the part of directives which have been given to state? Meaning इसको आप ऐसे भी पूछ सकते थे that which of the following are the DPSP or which of the following is a fundamental duty. ये differentiate करना आपको इस क्वेश्चन में that which of these are the DPSP and which of these are the fundamental duties, right? To value and preserve the rich heritage of our composite culture. This is a fundamental duty. जब monuments आएंगे for national interest, then it will become fundamental DPSP. To protect and improve the natural environment, including forest, lakes, and the wildlife. And to protect every monument or the place or the object of artistic or historic importance. Which of these are the DPSP? The first is a fundamental duty. Second is also a fundamental duty. Third is a DPSP. Third is a DPSP, right? So answer shall be C. दो confusing है. One is related to preserve rich and heritage of our composite culture. ऐसा एक हमारे यहाँ DPSP भी है with regards to monument and protection of environment that अभी we read. It is given under 48A. ऊपर देखो आप 48A वाला. You should take the steps कि आप गंदगी ना फैलाओ. You are not going to for poaching. बहुत सारे लोग तस्करी करते हैं वाइल्ड लाइफ की, तो वो एज ए सिटीजन आपकी ड्यूटी है कि आप ऐसे काम नहीं करेंगे. बट इट इज ऑल्सो द डायरेक्शन विच हैज बीन गिवन टू द स्टेट, बट द वर्डिंग्स आर डिफरेंट. आप देखो यहाँ पे क्या, टू प्रोटेक्ट एंड इंप्रूव द नेचुरल एनवायरमेंट इंक्लूडिंग फॉरेस्ट, लेक्स, रिवर्स एंड वाइल्ड लाइफ. दिस इज द हेडिंग. हियर यू विल फाइंड द हेडिंग प्रोटेक्शन एंड इंप्रूवमेंट ऑफ एनवायरमेंट, सेफ गार्डिंग ऑफ फॉरेस्ट एंड वाइल्ड लाइफ. सो बहुत माइन्यूट डिफरेंस है, राइट. दिस इज वाई इट इज यूजुअली आस्क्ड इन द क्वेश्चन. यहां पे फॉर 432 ओनली 3 यानी सी. दिस इज अ डीपीएसपी, दिस इज फंडामेंटल ड्यूटी, दिस इज फंडामेंटल ड्यूटी. For 33, consider the following statements. The Constitution has vested supreme command of defense forces of Union in the President of India, and the exercise thereof cannot be regulated by the law. Supreme, half of the statement is true. First part of the statement is true, but latter part that it cannot be regulated by the law, this is false. Because supreme command is vested in the president, but that thing can be regulated by the law of parliament. So this statement in total it is false, because this much portion is false. इसके पहले वाला the supreme command it is true. The executive power of union is vested in the council of ministers. The executive power of union it is vested in the president. This is specifically mentioned under article 53 of the constitution, right? So both the statements shall be false. Consider the following statements. Question number 434. The constitution tries to establish uniformity in the scale of representation of different states at the election of the president. True. For the purpose of securing such uniformity among the state among the state themselves, as well as parity between union at one side and states at other, combined states as other and union on one side, it has adopted a value of vote system. This is again the direct from the Bare Act. Bare Act के भी provision से ये दोनों स्टेटमेंट निकल के आए हैं, और दोनों ही स्टेटमेंट ट्रू हैं. दैट देयर should be uniformity in the scale as far as practicable in the representation which is given to different state for the election of the president. This is true. और इसी representation के लिए एक value of vote system हम adopt करते हैं, wherein the value of one vote of MLA is total number of votes divided by population into 1000. और जितने एक particular MLAs की वैल्यू ऑफ वोट है, तो सारे देश के सारे एमएलए की वैल्यू को वोट को डिवाइडेड बाय टोटल नंबर ऑफ इलेक्टेड एमएलए कर देंगे, तो आ जाएगा एमपीज का, राइट. तो देयर बोथ द स्टेटमेंट इज करेक्ट. Which of the following statement is not true? The election of the president shall be held in accordance with the system of proportional representation. हमें यहां पता करना है which of the following is not true. So first says the election of the president shall be held in accordance with the system of proportional representation by the means of single transferable vote. Second, voting at the presidential election shall be held by the secret ballot. This is also true. At present, while conducting the elections to the president, the population data is taken from 2001 census. It is not. It is from 1971 सेंसस। द पॉपुलेशन डेटा जो कि कितना होगा स्टेट का पॉपुलेशन डिवाइडेड बाय टोटल नंबर ऑफ MLAs इन द स्टेट इनटू 1000, जो वैल्यू ऑफ वोट निकालने की अभी हमने बात की। So the population of state shall be taken upon the basis of 1971 census. Elected members of legislature of Delhi and Pondicherry also votes during the election of the president. This is also true. But other union territories have got no representation, right? Because they do not have the elected members. So कौन सा statement false है? It is C. Consider the following statements. President may resign by writing to the vice president, and vice president should inform the speaker of Lok Sabha about such resignation of the president. It is required. यही है कि Bare Act में ये these are the things which is mentioned that as soon as the vice president will write to the vice president, but as soon as vice president is receiving, because president is the integral part of the parliament, so such communication needs to be informed to the स्पीकर ऑफ लोकसभा forthwith. जितनी जल्दी हो सके उतनी जल्दी स्पीकर ऑफ लोकसभा को भी बताना पड़ेगा. सो दिस इज रिक्वायर्ड प्रोविजन. सो इट इज रिक्वायर्ड, इट इज ट्रू. President can be impeached only on 2 grounds, that is incapacity and proven misbehavior. Yes. So these are the grounds of removal of the judges. Judges can be removed on the grounds of incapacity and proved misbehavior. President can be removed only on one ground, and that is violation of constitution. Violation of constitution, right? So first is true, second one is false. (437) Which one of the following statement is correct? A person holding office of vice president or governor cannot contest the election to the post of president, as they are already holding the office of profit. These posts are not considered as office of profit. So this is not correct statement. The emoluments and the allowance of president may be diminished during his term of office only by the parliament. It cannot be diminished during the term of the president. President shall, before entering upon his office, makes and subscribe in the president or vice president, or in his absence, senior most judge of the Supreme Court, oath. Oath लेते हैं किसके? CGI के presence में. It is not the vice president. So this statement is also false. A person who has already held the office of the president can contest for re-election, and no such limit has been prescribed. This is true. तो ऐसा कोई रिस्ट्रिक्शन नहीं है इंडिया के प्रेसिडेंट के ऊपर दैट वंस अ पर्सन हैज बिकम द प्रेसिडेंट ही कैन नॉट कंटेस्ट, या फिर मैक्सिमम अ पर्सन कैन बी द प्रेसिडेंट फॉर 2 tenure. ऐसा कोई लिमिटेशंस नहीं है. दीज काइंड्स ऑफ लिमिटेशंस आर देयर ऑन द प्रेसिडेंट ऑफ यूनाइटेड स्टेट्स, राइट? सो द आंसर हियर शैल बी डी. ऑल दीज 3 स्टेटमेंट A, B, C आर फॉल्स. 438 consider the following statement with regards to impeachment of president. First statement, at least 1/4 of the members of the house should give their intention before bringing the impeachment proceedings against the president. This is true statement, right? So impeachment of the president can be started in either house of the parliament, but before starting such, there has to be at least 1/4 of the member who is willing to start this proceedings, right? So first statement is false. Charges shall be investigated by the same house which has framed it. So once the Rajya Sabha suppose Rajya Sabha says president has done the violation of constitution, and 1/4 of the members of Rajya Sabha are also supporting these motions, so there will be voting and it should be transferred to the other house. The Lok Sabha then shall form an investigation committee, and that investigation committee, during that investigation committee, the president should be given the charge, should be given the opportunity to represent himself, right? So at least 1/4 of the member, this is a true. The charges shall be investigated by the same house. No, it is the other house which has framed. President shall have the right to appear during the investigation. This is true. A resolution needs to be passed by a majority of total membership of the house, which shall not be less than 2/3 of the present and voting. This is false. ये जो मेजोरिटी है ये कहाँ लगती है? अमेंडमेंट करने के लिए लगती है. But for the president, it is 2/3 of the total. Doesn't matter how many present and how many are voting. So it's simply 2/3 of the total membership of the house. In whichever house the voting is getting done, the 2/3 of the total membership of the house, right? So this is false statement. 1 and 3 is the correct, right? So third one is correct, first one is correct, A is the correct answer. 439. Consider the following statement with reference to the Constitution of India. Vice President leaves his office as soon as his term complete 5 years. Unlike the President, Vice President do not take any oath before entering into office. So Vice President also takes oath, right? But Vice President does not leave his office as soon as. So he will continue until his successor is appointed. Because why? He is also the chairman of the Rajya Sabha Secretariat. For that duty, it needed to be completed, right? So this statement is false because as soon as 5 years, ऐसा कोई जरूरी नहीं है. But as soon as the successor is appointed, he will have to demit his office in his favor, right? So here D is the correct one. Neither 1 nor 2 are the correct. 440. The total number of ministers, including the Prime Minister in the Council of Ministers, shall not exceed 15% of the total strength of the Parliament. The above provision was added by 52nd Amendment to the Constitution. Right? So it was added by the 91st Amendment. But it is not the total strength of the Parliament, it is the total strength of the Lok Sabha. These kinds of error, ऐसी error आपके 2-3 नंबर ऊपर नीचे कर सकता है. So first statement is false, second is also false. Answer is D. 52nd amendment से anti defection आया था. And in anti defection 10 schedule only this provision has been included. 15% की जो कैपिंग है वो 10 schedule में ही डाला गया है, but through a different amendment, 91st amendment. Consider the following statements. 42nd Amendment to the Constitution made a provision that President can send the advice tendered by the Council of Ministers for their reconsideration. 44th Amendment Act made it mandatory upon the President to act in accordance with the advice given by the Council of Ministers. Ulta hai, right? So it was the 42nd Amendment which made this provision that President shall act on the advice, only on the advice of the Council of Ministers. But however, certain relaxation was given to the President by the 44th Amendment, and it allowed the President to send for the reconsideration. But once the Council of Ministers sends back the advice after reconsideration, it is binding upon the President to follow that, right? So D will be the answer because none of them are correct. Both are interchanged. 44th को 42nd में लिख दिया and 42nd को 44th में लिख दिया है. 442. Which of the following statement is correct? The Council of Ministers shall be collectively responsible to the Parliament. अभी है सही. The Council of Ministers shall be collectively responsible to, not to the Parliament, but it is responsible only to the Lok Sabha. Parliament has other organs also. A member of Parliament who is disqualified on the grounds mentioned under 10th schedule can continue to be a minister. This is also false. Once a member has been disqualified on the ground of anti-defection under 10th schedule, he can not continue to be also disqualified from being the minister. President shall administer to a minister the oath of office and secrecy according to the form which has been set out under the 3rd schedule of the Constitution. यहाँ पे शेड्यूल भी सही है, पर्सन भी सही है और ओथ ऑफ ऑफिस एंड सेक्रेसी ये भी देखना था आपको कि मिनिस्टर्स टेक द ओथ ऑफ ऑफिस और सेक्रेसी और नॉट. Ministers, including the Prime Minister, take the oath of office and secrecy. President and Vice President do not take any such secrecy oath. Right? So, ये statement सही है. Ministers are appointed by the President and hold office till next 5 years. ऐसा कोई rule नहीं है. This simply pleasure of President का doctrine है. So, ministers are appointed by the President, can be removed by the President as per the pleasure. However, they cannot be removed until they are holding the majority. So, collective responsibility towards the Lok Sabha. 443 question number. Consider the following statement. The President shall appoint a person who is qualified to be appointed as Judge of Supreme Court to be the Attorney General of India. In the performance of his duty, Attorney Generals have a right of audience in all courts in the territory of India. Third one says, Attorney General have the security of tenure and can be removed only by the President in like manner as the judge of Supreme Court. So these are the three statements. कि सबसे पहले Attorney General is the person, he is the chief legal advisor of the government of India, and he is appointed by the President. Then what is his qualification? The person need to be qualified to become the judge of the Supreme Court. This is true. Now, Attorney General has certain powers and functions. Whenever there is a requirement to answer about the government's stand, जैसे भी same sex marriage पे चल रहा है, so it is the duty of the Attorney General to go and answer the stand of the, clear the stand of the government, central government before the Supreme Court. However, he is the only person. बहुत सारे उस पर वर्कलोड सकते हैं. To assist him, there are various other solicitor generals. So अभी solicitor general जाते हैं अपने सुप्रीम कोर्ट में आंसर करने सेम सेक्स मैरिज पे, राइट? तो वो उसकी ड्यूटी है. एंड व्हाइल परफॉर्मिंग हिज ड्यूटी, अटॉर्नी जनरल हैव द राइट टू अटेंड एनी कोर्ट्स इन इंडिया. हमारे आपको नहीं है, बिकॉज एनी अदर पर्सन नीड्स द परमिशन फ्रॉम द कोर्ट. कोर्ट को चाहिए, एक लॉयर का आप स्टैंप लगा के जाओगे तभी आपको देखने की अनुमति है अबाउट द कोर्ट्स प्रोसीडिंग. बट अटॉर्नी जनरल हैज दिस राइट. Not only this right, Attorney General also has the right to speak and participate in either house of the Parliament, but he has no right to vote in the proceedings of the Parliament, right? So this statement is also true. Now the third statement says, Attorney General shall have the security of tenure and can be removed only in same way as the Judge of Supreme Court of India is. So this statement is false. It depends upon the pleasure of the President. So परंपरा ये कहती है, the tradition says that once the government is resigning, Attorney General resigns together with the government, क्योंकि वो नई गवर्नमेंट आएगी और अपना नया कंसल्टेंट हायर करेगी, राइट? सो फर्स्ट एंड सेकंड इज द करेक्ट ऑप्शन. द थर्ड वन इज फॉल्स. 444. Consider the following statement. All executive actions of the government of India shall be expressed to be taken in the name of the President. The President shall make rules for the more convenient transaction of the business of the government of India and for the allocation among the ministers of the said business. Both the statements are directly taken from the Bare Act. Both these statements are correct. जितने भी एग्जीक्यूटिव काम होते हैं प्रेसिडेंट के नाम पे ही लिए जाते हैं, and it is the power of the president, rule making power of the president for the conduct of businesses. All the rules are framed by the president. Of course, president is bound to advise on the council of ministers advice, right? So this is C. 445. Consider the following statement. While constituting the Council of State, union territories are not given the representation. Union territories are given representation. So this statement will be false. Person having special knowledge from literature, science, art, social service and sports can be nominated by the President to the Council of States. So sports is not included. This is हमारे कॉन्स्टिट्यूशन में लिखा क्या है? लिटरेचर, साइंस, आर्ट एंड सोशल सर्विस. दीज आर द 4 grounds. So person having special knowledge from these 4 areas can be nominated. So 12 altogether, 12 such members are nominated to Rajya Sabha and they belong from these backgrounds. However, you will find at some occasion certain sports persons are also nominated, but there is no such ground which is mentioned. तो उनको सोशल सर्विस के एंट्री दे देते हैं. सोशल स्पोर्ट्स, हाउ स्पोर्ट्स इज मोर ऑफ स्किल. हाँ, तो सचिन तेंदुलकर को सोशल सर्विस से नॉमिनेट किया था ऑन द कैटेगरी ऑफ सोशल सर्विस. हाँ, ऑफ कोर्स. तो यू विल करेंगे ना, जैसे लिटरेचर से किसी नॉवलिस्ट आए गए, रेखा बिलोंग्स टू आर्ट, तो रेखा जी वाज अपॉइंटेड, तो वो आर्ट फॉर्म हो गया सिनेमा आपका. सर्टेन डांसर्स, क्लासिकल सिंगर्स, दीज में बी नॉमिनेटेड ऑल्सो. सो डिपेंड्स दैट स्पोर्ट्स इज नोवेयर मेंशन्ड, राइट? बट ये एक 5वां कैटेगरी ऐड हो जाता है व्हेन इट इज अबाउट द नॉमिनेशन इन द लेजिस्लेटिव काउंसिल, राइट? सो नॉमिनेशन in this like manner, the persons can be nominated. 12 nominated members can be there in the Rajya Sabha. In the similar manners, 1/6 of the persons in the legislative council of the state, wherever the 6 states are there. So उन 6 states में 1/6 of the members of the legislative councils are nominated by governor. तो उसमें कौन से फील्ड हैं? लिटरेचर, साइंस, आर्ट, सोशल सर्विस एंड कोऑपरेटिव मूवमेंट. तो लेजिस्लेटिव काउंसिल में नॉमिनेशन के समय ये एक एडिशनल ग्राउंड आ जाता है. बट राज्यसभा के लिए these are the foreground: literature, science, art and social service. This makes the second statement as false. First statement is already false, neither one nor two, right? Moving on, 446. Consider the following statements. The allocation of seats in the House of People and House of People to the states and division of each state in the territorial constituencies shall be readjusted after every census. तो ये delimitation की बात कर रहा है. Originally, Constitution of India provided that delimitation has to be conducted after every 10 years, after every census has been done. So this statement is true. Delimitation is act of dividing India into a different constituencies. तो एक स्टेट में कितनी कॉन्स्टिट्यूएंसी होगी और उस स्टेट के अंदर कितनी सारी कॉन्स्टिट्यूएंसीज होगी, that depend upon the delimitation, and this was supposed to be done after every census, but due to this disparity in the population it was paused. तो second statement वही कहता है, the readjustment has been paused by 84th Amendment Act 2001 until the relevant features for the first census taken after 2026 has been published, right? तो कई फेजेस में हुआ. पहले by the 42nd Amendment Act it was paused that the relevant figures of 1971 will be taken. फिर उसको बढ़ा के 2001 कर दिया. So at present the provision which is applicable after 84th Amendment, it says कि जब तक 2026 के बाद सेंसस नहीं हो जाता और उसका डेटा नहीं आ जाता, देश में लोकसभा कॉन्स्टिट्यूएंसीज के डेलिमिटेशन नहीं होगी, राइट? सो दिस स्टेटमेंट स्टैंड्स ट्रू, राइट? So both the statement are true. 447. Consider the following statements. While proclamation of emergency is in operation, the tenure of Lok Sabha can be extended for a period not exceeding 1 year at a time. नहीं, वो दूसरी चीज का है. That is for the emergency itself. Emergency itself can be extended for a period of 6 months, right? But during emergency, the tenure of Lok Sabha can be exceeded. But एक बार में एक साल से ज्यादा नहीं. दोबारा जरूरत पड़ेगी, you can exceed by another year. But at one time, it cannot extend for beyond 1 year, right? Now, the first statement is true. कि जब भी मान लो इमरजेंसी लगी है, उस समय लोकसभा का टेन्योर बढ़ाया जा सकता है. ट्रू है. एक बार में मैक्सिमम कितने टाइम के लिए बढ़ाया जा सकता है? 1 साल के लिए. When it is about the emergency itself, national emergency, it can be extended for a period of 6 months and then required again 6 months, then required again 6 months. Up to a national emergency, any number of time, right? As far as required. President rule up to 3 years maximum, right? So this is true statement. Now second says it is mandatory to conduct the elections. Mandatory to conduct the elections within 6 months of the expiration of emergency if Lok Sabha is already on extended tenure. तो दो सिचुएशन होती है. इस क्वेश्चन के कहने का मतलब क्या है कि सपोज इफ देयर इज एन इमरजेंसी, द रूल सेज इफ देयर इज एन इमरजेंसी व्हिच इज देयर इन इंडिया, फर्स्टली Lok Sabha can be extended. It can be extended for 1 year at a time. Now, suppose that if emergency was applied and Lok Sabha was extended, then what about the emergency expired? जब emergency expire हो गई है, तब क्या लोक सभा को और भी extend करते रहना चाहिए? Or will it be required to conduct the election? So the day when emergency itself expires, within 6 months of that date, it is mandatory for conducting of Lok Sabha election if emergency was already on the extended tenure. हमारे हुआ था 1975 में जब इमरजेंसी लगी थी, लोकसभा का टेन्योर एक्सटेंड किया गया था. इट वाज आइडियली द इलेक्शन वाज कंडक्टेड इन 1971, सो इट शुड हैव बीन कंप्लीटेड इन 1976, बट उसको 1978 में इलेक्शंस कराए गए. सो इट वाज एक्सटेंडेड फॉर 2 years. So this statement is also true. इमरजेंसी के समय लोकसभा का टेन्योर कैन बी एक्सटेंडेड by 1 year at a time, but from the date when the emergency ceased to have effect, within 6 months there will be requirement to conduct the fresh elections to the Lok Sabha, right? Both the statements are correct. 448. Unlike the President of USA, the President of India cannot send any message to the House of Parliament with respect to bill pending therein. This is false statement. President can send message to with respect to bills. He is the integral part of the parliament. The original constitution contained a provision that before commencement of every session of the parliament, the president shall address both the houses of parliament. Now, you should know that the present present provision says that before commencement of first session of each year, that is budget. So, before commencement of first session of each year, the president will address the joint sitting. That is one statement. This is true. There is another feature that says that if there is a Lok Sabha election, so before having the first sitting of the Lok Sabha, president will address. So this is present. But original constitution में क्या लिखा हुआ था? That before every session, president will have to address. Before every session. First Amendment Act में change करके अभी वाला feature ला दिया गया. That first session of every year, and if there is an election to the Lok Sabha, so first sitting before that election. ओरिजिनली यही लिखा हुआ था कि हर सेशन से पहले एक बार प्रेसिडेंट आएंगे, चाहे वो ऑटम में आए, चाहे वो मॉनसून में आए, तो दो किसी भी सेशन में उनको आना पड़ेगा, राइट? तो दिस इज फॉल्स स्टेटमेंट, दिस इज ट्रू स्टेटमेंट, बी इज करेक्ट, राइट? (449) Consider the following statement. A person who is a minister can speak and vote in either houses of parliament. He can speak, cannot vote. एक पर्सन जो मिनिस्टर है, be it he is from the Lok Sabha, but he may go and participate and discuss, speak in the Rajya Sabha, but is not allowed to vote there, right? First statement becomes false. The Attorney General of India has a right to speak in both the houses of parliament, but no right to vote in either houses of parliament, right? That we have already discussed. Question number 450. It says, consider the following statement. The Deputy Chairman of Council of State may be removed from his office by a resolution of Council of State passed by majority of the then members of the Council. This is what is called effective majority. This is true statement. No such resolution shall be moved unless he has got the 14 days prior notice. True, right? So both the statements are true here. 451. Consider the following statements. While the motion of removal of speaker is going on under the process, he is not entitled to preside over the sitting. However, he can take part in other proceedings. He will sit in the audience. He will also have the right to vote. Now, first statement becomes true hence. While the motion of removal of speaker is pending, he is entitled to vote at first instance. Ideally, speaker is not entitled to vote at first instance. जब उसके खुद की रिमूवल की बारी चल रही है, then he will be eligible to vote at first instance also, right? So this statement is true. (452) Consider the following statement. Speaker has no power to reject the resignation tendered by a member. He has the power. If the speaker comes to know that this resignation is not voluntary, someone has forced him, or he is this is not a genuine resignation for genuine purposes, so he has the power to reject it, right? Secondly, if for a period of 30 days a member of either house of the parliament is absent without the permission of the house from all its meeting, house may declare his seat as vacant. So it is not 30 days, it is 60 days. It is 60 days. They has the power, speaker has the power. Both the statements shall be false. Which of these statements is not correct? A bill pending in the Council of State which has not been passed by the House of People shall not lapse on its dissolution. A bill which is pending in the House of People shall lapses on the dissolution. True. We have to find not correct. A bill pending in the Council of State and have been passed by House of the People shall lapse on its dissolution. True. A bill pending in the House of People shall not lapse by the reason of prorogation of the House. Actually, there is a mistake for all the statement. So, यहाँ पे it was thought to be shall lapse by the reason of prorogation. So, if we read the statement like this, a bill pending in the House of People shall lapse by the reason of prorogation of the House, then this statement will be false, right? Otherwise, द बिल शैल नॉट लैप्स ऑन द प्रोरोगेशन ऑफ हाउस, राइट। पहला एक स्टेटमेंट क्या कहता है, a bill pending in the council of state, this means the bill is there, it is pending in the Rajya Sabha and has not been passed by the house of people, अभी लोकसभा से पास नहीं किया गया, this means it has not come in the Lok Sabha, shall not lapse, right? So this is true statement. Pending here, not passed in the Rajya Sabha, हमने एक टेबल करके भी किया हुआ है, we have done that, so quickly we'll need to revise. A bill which is pending in the house of people shall lapse on its resolution. This means राज्यसभा से भी कोई मतलब ही नहीं है, आया है नहीं आया है, but simply it is pending here, it will lapse, right? A bill which is passed by the Lok Sabha, a bill which is pending in the council of state, so it is passed by the Lok Sabha and pending in the Rajya Sabha, it shall lapse, right? There is no impact of prorogation on the bill, right? However, the motion shall cease, motions expire हो जाते हैं. Like if there is a motion for removal of judges and the house is prorogued, the session ends, then that motion shall lapse. Again, you will have to start the fresh proceedings. Bill का prorogation of house का कोई effect नहीं होता है, right? Question 454. A bill shall not be deemed to be a money bill if it contains provisions dealing with all or any of the following matters. Actually, ये again it is coming out of 110. ऐसा क्वेश्चन है कि यूपीएससी भी पूछ चुकी है, स्टेटमेंट्स मैंने अलग रखा है, उन्होंने कुछ अलग रखा था, ठीक है। इनमें से कौन सा है जो मनी बिल नहीं कहलाएगा, वी हैव टू फाइंड इट। द रेगुलेशन ऑफ द बोरोइंग ऑफ मनी और गिविंग एनी गारंटी बाय द गवर्नमेंट ऑफ इंडिया। So you know government of India and even government of state can borrow or give guarantee on their respective consolidated fund, right? So any bill which is regarding that may be called as money bill, उसको हम money bill बोल सकते हैं, right? B says the appropriation of money out of the contingency fund of India. So if it is there appropriation of money out of consolidated fund of India, then it will be called a money bill. कॉन्टीजेंसी फंड ऑफ इंडिया से पैसे निकालने के लिए किसी भी बिल की जरूरत नहीं पड़ती है, दैट इज अवेलेबल एट द डिसबर्सल ऑफ द प्रेसिडेंट। सो दिस विल बी अ फॉल्स स्टेटमेंट, दिस इज नॉट अ मनी बिल, दिस विल बी आवर आंसर। बट आगे भी देखिए, द रिसिप्ट ऑफ मनी ऑन द अकाउंट ऑफ पब्लिक अकाउंट ऑफ इंडिया, पब्लिक अकाउंट में जो भी पैसे ला रही है गवर्नमेंट, दैट इज ऑल्सो अ मनी बिल। कस्टडी ऑफ कॉन्टीजेंसी फंड ऑफ इंडिया, दैट इज ऑल्सो अ मनी बिल। इट इज द अप्रोप्रिएशन ऑफ मनी आउट ऑफ कॉन्टीजेंसी फंड, इसके लिए कोई बिल की जरूरत नहीं पड़ती। But bill changing the custody of the contingency fund of India, or it is talking about the custody of contingency fund of India, this will be the money bill, right? So money bill का जो exact definition है आर्टिकल 110 के अंदर है। आप टाइम मिले तो एक बार उसको पढ़िए जरूर। You should go through that all the provisions, and all those 6 provisions are very very important. 455. Which of the following is or are the expenditure charged upon the consolidated fund of India? तो आर्टिकल 112 जो है हमारे कॉन्स्टिट्यूशन में, that talks about the presentation of budget, and that article itself under sub clause 3 it talks about the various expenditure which has been considered as expenditure which are charged upon the consolidated fund of India. तो इसमें से पूछ रहा है which are the expenditure charged upon the consolidated fund of India? Any sum required to satisfy any judgment, decree or award of any court or arbitral tribunal. Is this a expenditure charged? Expenditure charged upon the consolidated fund of India. तो सी जब सरकार consolidated fund of India से पैसे appropriate कर रही होती है, so there are 2 ways. One is expenditure charged upon the consolidated fund of India, another is expenditure made from. So those expenditure which are put as expenditure charged, parliament cannot vote upon that. तो इन पे voting allowed नहीं होती है। All those expenditure can be voted. Voted का मतलब होता है parliament can reduce that. Expenditure charged means it cannot be reduced. ऐसा किस लिए किया जाता है? Just in order to give independence to the authority कि उनकी सैलरीज, उनके खर्चों को पार्लियामेंट कम न कर सके, पार्लियामेंट के कंट्रोल उन अथॉरिटीज के ऊपर ना हो, उन अथॉरिटीज की फाइनेंशियल डिपेंडेबिलिटी ना हो, राइट? सो इट सेज एनी सम्स रिक्वायर्ड टू सेटिस्फाई, दिस इज ट्रू. The pension payable in the respect of judge of any high court, this is true. See, we are talking about the consolidated fund of India, तो confuse नहीं करना हाई कोर्ट का. Pension of the high court judges are paid out of consolidated fund of India. Salaries are paid out of consolidated fund of respective state. Debt charges for which government of India is liable, this is also the charged, expenditure charged, right? So all of the above shall be the answer. (456). In case of absence of Chief Justice of India, Parliament may appoint any sitting judge of the Supreme Court as acting Chief Justice of India. It is दो गलत है. President even can appoint, not the Parliament, right? So this is false. A sitting judge of High Court, when appointed as an ad hoc judge of the Supreme Court, shall give priority to attend the sittings of the Supreme Court at that time period for which his attendance is required over his other duties. The once person, see, if there is a lack of quorum in the Supreme Court, मतलब Supreme Court में जजों की संख्या की कमी हो गई है, in that circumstances, a person who is eligible to become the judge of the Supreme Court, however, he is already not the judge of Supreme Court, they are serving in the High Court. मान लीजिए High Court में 10 साल से practice कर रहे हैं, judge हैं. So all those persons become eligible. So those persons can be pulled from there and maybe for an ad hoc time, that is for a temporary period, they are asked to. But at that point of time, जब वो ad hoc judge का काम कर रहे हैं, he should give the priority to the Supreme Court work, keeping his all other duties aside, and this is specifically mentioned in the Constitution, right? So this is true statement. 2 is correct. Consider the following statements. The Supreme Court shall have the power of such a court. Supreme Court is court of record and shall have the power of such a court, including power to punish for contempt of itself. True. High courts can only punish for its own contempt and not for any court subordinate to it. It is incorrect. See, Supreme Court contempt of court means आप अदालत की अवमानना कर रहे हैं, you are violating the judgments of the court. जैसे अभी सुप्रीम कोर्ट ने वर्डिक्ट दे दिया कि दिल्ली में सर्विसेज को कंट्रोल करने की पावर दिल्ली गवर्नमेंट के. नाउ यूनियन गवर्नमेंट वाज नॉट एग्रीइंग टू इट, सो पीपल से फाइल द कंटेम्प्ट ऑफ कोर्ट. मीनिंग कोर्ट, कंटेम्प्ट ऑफ कोर्ट के दो मतलब होते हैं. वन, देयर इज अ विलफुल डिफायंस ऑफ द ऑर्डर. सेकंडली, इफ समवन इज क्रिएटिंग एनी ऑब्स्ट्रक्शन इन द डिलीवरी ऑफ जस्टिस, कि कोई विटनेस पूछने आता है कि भाई कोर्ट का रास्ता कहाँ है, आपने उसको गुमराह कर दिया, कहीं और है. यू आर मैनिपुलेटिंग द थिंग्स. आप अदालत सामने आके बार बार झूठ बोल रहे हैं, सो दैट यू आर simply eating away the time of the court. However, giving false evidence on oath, affidavit गलत देना, that is a kind of perjury. उसके लिए offense है. But that is also you are misleading the court. That is obstruction in the path of justice. तो उसको contempt of court बोलते हैं. Contempt of court के लिए there is a contempt of court act that regulates the things also. If you talk about the Constitution of India, both Supreme Court and High Court have the power to punish for the contempt. Supreme Court can punish for contempt of its own and any other court in India. High Court can punish for its own contempt and all the courts which is subordinate to it. ये वाला जो portion है वो Constitution में नहीं लिखा हुआ है. That a High Court can punish for others court contempt. This is not mentioned in the Constitution, but this is mentioned in the Contempt of Court Act. Contempt of Court Act पे last year question भी आया था. Right? तो प्रोविजन तो वैसे सही है, चाहे वो कहीं से भी आए. क्वेश्चन में आपको ये थोड़ी जज करना है ये कॉन्स्टिट्यूशन में. Had I written that constitution, it is prescribed under the constitution, this will be a false statement, right? So High Court can punish, only punish for its contempt. This is a false statement. Supreme Court can punish for its contempt. This is true statement. In which of the following disputes the original jurisdiction of Supreme Court shall prevail between two or more states, if in so far as the disputes involve any dispute of law or fact on which existence of legal right depends. States के बीच में दो तरह की disputes हो सकती है. One is related to the rights of which may be created due to constitution or any other law. Law के कारण, उन law की power sharing के कारण कोई disputes हैं. That is the part of original jurisdiction of the Supreme Court. Ordinary commercial disputes between the state. उसने यहां से सोना खरीदा, उसने यहां से कोयला खरीदा. Those are the commercial disputes. These are not the part of original jurisdiction of the Supreme Court. A dispute arising out of any treaty entered or executed before the commencement of the Constitution, this is not the part of original jurisdiction of the Supreme Court. This may be part of other jurisdiction of the Supreme Court, but specifically आप Article 131 पढ़ोगे that talks about original jurisdiction. तो उसमें एक exception है that says if there is any dispute arising out of any treaty entered into or executed before the commencement of this Constitution, तो वो फॉल्स होगा क्योंकि वो सुप्रीम कोर्ट के ओरिजिनल ज्यूरिसडिक्शन का पार्ट नहीं है. राइट? This is false, right? So statement is 1 only. Which of the following statement is correct about the office of governor? The emoluments and the allowances of governor shall not be diminished during the term of his office. The governor shall not hold any other office of profit. Governor shall not be the member of either house of parliament, either the house of parliament or house of the legislature. Even if the term of governor expire, he shall continue to hold office until his successor. All are correct. So these are the simple, एक आर्टिकल में जो गवर्नर के रिलेटेड जो भी है तो उनके प्रोविजंस को यहाँ पे इकट्ठा किया गया है. So all of the above is correct. B is the correct choice. 460. Consider the following statements. If Council of State passes a resolution that it is necessary or expedient in the national interest, Parliament is enabled to enact even in the state list. This is the provision which is mentioned under Article 249. Right? That firstly, Parliament को अगर state list में बनाना है तो it cannot. State list are the jurisdiction of state legislature. But there are certain occasions. One is 249. It says if it is expedient in the national interest, then firstly Rajya Sabha will pass a resolution and then Parliament together will make law. Second says such a resolution needs to be passed by a majority of total membership of the House and not less than 2/3 of the present and voting. False हो जाएगा because majority of total membership of the House is not required there. It is simply 2/3 of the members present and voting. Right? And any law in such a manner shall not have effect after a period of 6 months from the date which a resolution passed by Council of State shall cease to have effect. मतलब if the under this resolution has been passed by the Rajya Sabha today, right? आज मान लीजिए राज्य सभा ने resolution पास किया है. What is the validity of that resolution itself? Is that eternal? क्या वो हमेशा के लिए रहेगा? नहीं, 1 साल के लिए रहेगा. The resolution which is passed by the Rajya Sabha shall be valid for 1 year and can be extended by 1 year, right? और इस resolution का use करके if Parliament has enacted any law in the state list, that shall be valid for a period of 6 months from the date resolution is expiring. तो जिस दिन resolution itself खत्म हो जाएगा, from that day 6 months only the law will be applicable, right? Okay. So 460 answer shall be B. 1 and 3 is correct. 461. Consider the following statements. While a proclamation of emergency is in operation, Parliament shall have a power to make laws on any of the matters enumerated in the state list. True. Any such law made during the emergency shall in toto means in total, shall cease to have effect on the expiration of period of 6 months after the proclamation has ceased to operate. ये भी false हो जाएगा because the word it is written here is in toto. मतलब total पूरा का पूरा नहीं. देखो सबसे पहले क्या होता है कि now ideally the power of Parliament gets activated during the time of emergency, right? So law का वो portion ही violate होगा. If using this power, if Parliament is making any law, तो इमरजेंसी के दौरान कुछ हमारे फंडामेंटल राइट सस्पेंड हो जाते हैं या फिर कुछ भी इमरजेंसी के दौरान ड्यूरिंग द इमरजेंसी पार्लियामेंट गेट सर्टेन पावर टू डू समथिंग, अदरवाइज दे आर नॉट. एंड नाउ व्हाइल पार्लियामेंट इज इनैक्टिंग समथिंग इन अ लॉ व्हिच इज दे हैव गॉट पावर ओनली ड्यू टू इमरजेंसी. सिर्फ इमरजेंसी कारण जो पावर मिली है उतना ही पोर्शन इसमें इनकंसिस्टेंट होगा, नॉट द अदर पोर्शन. मान लीजिए कोई एक फंडामेंटल राइट था, ड्यूरिंग द इमरजेंसी someone's article 15 is violated. आर्टिकल 15 को हमने सस्पेंड किया तो पार्लियामेंट ने स्टेट लिस्ट में कानून बनाते समय डिड द वायलेशन ऑफ आर्टिकल 15. दैट वाज क्वाइट परमिसेबल क्योंकि देश में इमरजेंसी चल रही है. नाउ आफ्टर द इमरजेंसी इज ओवर, दैट मच पोर्शन ऑफ वायलेशन ऑफ आर्टिकल 15 शैल बी वाइड विद इन 6 months, not the whole law itself, right? So this statement will be false. This is true. 462. Consider the following statement. In case of a conflict between the laws made by Parliament and the legislature of the state, in the concrete list, the law made by the state shall prevail if it was enacted before the law of Parliament. Any which way, चाहे पार्लियामेंट की लॉ पहले बने या पार्लियामेंट की लॉ बाद में बने, on the matters of congruent list, the law made by Parliament shall prevail except one situation, right? तो फर्स्ट स्टेटमेंट shall be false. और जो एक्सेप्शन है वो कहां दिया है? इस स्टेटमेंट में दिया है. If a law made by the state legislature on any matters which is given in the concurrent list, तो concurrent list में कोई मैटर है, उस पे स्टेट की लेजिस्लेचर है वो ऑलरेडी मेड द लॉ, एंड वाइल मेकिंग ऑफ दैट लॉ, that law was reserved for the assent of the president, and president has successfully assented that law, and now that law is coming into conflict with the law made by the parliament, so the law made by the state legislature shall prevail, right? So this is true. (463). Consider the following statement: the executive power of every state shall be so exercised as to ensure the compliance with the laws made by the parliament and any existing laws which apply in that state. So this is certain obligation which have been put upon the state by the parliament in terms of center-state relationship. So this statement is true. Second statement says the executive power of the union shall extend to giving directions to the state. This is also true, right? Union can give directions at multiple occasions, right? And violation of those mandatory directions may cause imposition of the president rule, because this is mentioned under article 365 that अगर कोई स्टेट जो है पार्लियामेंट यूनियन के द्वारा दिए गए डायरेक्शंस को does not follow or violates that, this shall be constituted as failure of constitutional machinery, और उस सिचुएशन में क्या लगता है, प्रेसिडेंट रूल लग सकता है. See, 356 is prescribing how president rule can be imposed. How president rule can be imposed. What are the grounds of imposition of president rule? अब 365 में क्या कहता है कि if there is a violation of direction, this is also a kind of failure of constitutional machinery. 365 क्या बोलता है कि if there is failure of constitutional machinery, then president rule can be imposed, right? 365 बोलता है कि ऐसा भी करना एक फेलियर ही होता है. तो दिस इज लाइक कि अगर ऐसा होगा तो ये लग सकता है ना. 464. The president may, with the consent of governor of the state, entrust either conditionally और अनकंडीशनली टू दैट गवर्नमेंट. मतलब प्रेसिडेंट जो है यूनियन के एग्जीक्यूटिव पावर्स को स्टेट को क्या ट्रांसफर कर सकते हैं. तो देयर इज अ प्रोविजन फॉर ट्रांसफर ऑफ पावर्स. बोथ स्टेट कैन विद द कंसेंट ऑफ द यूनियन ट्रांसफर सर्टेन एग्जीक्यूटिव पावर, एंड यूनियन में प्रेसिडेंट भी गवर्नर के थ्रू स्टेट को एग्जीक्यूटिव पावर ट्रांसफर कर सकते हैं. हियर द कंसेंट ऑफ बोथ द पार्टीज आर required and this is necessary, right? So first statement is true. Second says governor cannot, so this will be a false statement. Governor can also, but with the prior consent of the union, right? So यहां लिखा गया with or without, दोनों तरीके से नहीं कर सकता. तो without the consent governor cannot do, but with consent governor can also transfer the executive powers. So A is the answer. 465 says which of the following forms the part of consolidated fund of India? Consolidated fund of India का इसमें से कौन कौन सी चीजें आती है? All revenues received by the government of India, all loans raised by the government by the issue of treasury bills. तो treasury bills बेच के जो गवर्नमेंट पैसे कमाती है, that is indeed a loan because that will have to be paid to the persons who has bought the treasury bill. Loans or wage and advance, this is also the part of the consolidated fund of India. All money received by the government in repayment of loans. भारत सरकार से किसी ने लोन लिया और वो भारत सरकार को वापस दे रहा है. So this is also the part of consolidated fund of India. All of the above is the part of consolidated fund. Now, 6th schedule of the Constitution of India makes the special provision with regard to which of the A? It's Assam, Meghalaya, Tripura and Mizoram. What is the maximum number of members in the Tribes Advisory Council? दो चीजें होती हैं. One is Tribes Advisory Council and this is in the 5th schedule. But there is Autonomous District Council. Autonomous District Council. So this is applied in the 6th schedule areas. यहाँ पे 30 members होते हैं, right? 26 are elected directly. 26 out of this 30, 26 are elected by universal adult suffrage, direct elections के through. And 4 are nominated by governor. But this is applicable only to the 6th schedule states, right? For 5th schedule state, there should be a Tribes Advisory Council and it shall constitute of 20 members, right? Who has the power? Who is empowered to declare an area to be a scheduled area? President of India can declare any area to be scheduled area. Article 359 of the Constitution of India deals with which of the following? Yes, see, it is suspension of the enforcement of fundamental rights. So, few fundamental rights. So, Article 359 says all the fundamental rights except which is given in 20 and 21. 20 and 21. So, 20 is conviction of offences and 21 is right to life and personal liberty. However, this was not in the original provision. This is added by the 44th Amendment Act. Exceptions to these rights, that these rights cannot be suspended even during the national emergency. So, दो article है, one is 358 and another is 359. 358 says if there is a national emergency on the grounds of war or external aggression, then the rights which has been given under Article 19 gets automatically suspended. So 358 talks about automatic suspension only of Article 19. Now 359 talks about suspension of all other articles except 20 and 21. Right. So this will be C is the answer. 470 says which of the following pairs is not correctly matched? Protection of childhood and youth from exploitation. It is the part which is one of the directions which is given to the state under Article 39. 39 E or F mate is there. Right. So 39A is socialist principles. B and C is related to prevention of concentration of wealth. 39B and C are exceptions for 14 and 19. Right. So this is true. First one is true. It is the part of DPSP. Right to work education. This is also true under Article 41. Provision for early childhood care and education to children below 6 years under Article 45. This is also true. Earlier ये क्या था? It was right to education up to 6 to 14 years. But 86th Amendment Act में इसको early childhood care के बारे में कर दिया गया है for children below 6 years. 6 to 14 years is now made a right to education under Article 21. So that is justiciable now. Protection of monuments and places and the objects of national importance. This is not in 48A. This is in 49. 48A में क्या है? Environment वाला. अभी हमने ऊपर देखा था starting में. Right? So D will be the answer. D is not correctly matched. Which of the following is not the part of the state list in the 7th schedule of the Constitution? Relief of the disabled and unemployable people, taxes on lands and building, prisons. These 1, 2, 3 are the parts of state list. Stock exchanges are the part of union list. Stock exchanges, futures market, derivatives, all these are the parts of union list. तो ये union list के अंदर आएगा. Law and order, prison, these are the parts of the state list. तभी दिल्ली में prison department के 90 staffs को रातों रात हटा दिया उन्होंने. Which of the following article of the Constitution contained the definition of various terms which is used in the different provisions of the Constitution? आपके पेपर में भी कई बार आता है that which of these are defined under the Constitution. So ideally will come to know while you are reading कि what does law mean. तो law article 13 में define कर दिया. What does state mean? article 12 में define कर दिया. But जो भी चीजें कहीं भी नहीं define की गई है, there is a separate provision in the Constitution which deals with a certain definition. What do you mean by scheduled caste? What do you mean by scheduled tribes? What is agricultural income? तो ऐसे चीजों की definition जो दी गई है आर्टिकल 366 में दी गई है. Before going to examination, आपको एक बार आर्टिकल 366 पूरा देख लेना चाहिए that what all things are defined there. Otherwise, तो you know what is defined in the different provisions. 366 में specifically किन चीजों की definition दी गई है that you can see. What does the Constitution 92nd Amendment Act deal with? Creation of a separate National Commission for Scheduled Caste, cyber crimes, inclusion of Bodo, Dogri, Maithili, Santhali language in the 8th schedule, making right to free and compulsory education as a fundamental right. This is 86 C. कुछ languages को हमने scheduled language का दर्जा दिया था that included Bodo, Dogri, Maithili and Santhali. This was by the way of 92nd Amendment Act. 474. 93rd Amendment Act deal with basic structure is not through an amendment. Appointment of judges in the Supreme Court. This was not through amendment. However, There was 99th Amendment Act, creation of NJSC, but this has been declared as unconstitutional even then. Local self-government, 73rd and 74th. So extension of reservation in educational institutions, 93rd Amendment Act. 475, consider the following. The net proceeds of the taxes received by the union is certified by the parliament. It is certified by the CAG. CAG. It is not certified by the parliament. It is certified by the CAG of India. Net proceeds means कि जितना आपने टैक्स कलेक्ट किया और उसके कलेक्शन में कुछ खर्चा कर दिया. Suppose that if 10 people are giving 10 rupees each and you have appointed 20% for that. So what is your net benefit out of it? That is called net proceeds. So second is defining the net proceeds. So net proceeds mean the relation in relation to any tax, the duty of proceeds which is on the cost of the collection. ये actually constitution में defined है. So sometimes अगर बहुत weirdly ये question पूछता है net proceeds is defined or not, so it is defined, right? So this is true statement. 2 is the correct. Who appoints the judicial officers of subordinate judiciary other than the district judge? So we have seen 2-3 provisions. One is 236, 237 with regards to appointment of subordinate judiciary. So usually there will be Supreme Court, then there will be High Court, right? Then there will be district judge, and then there will be persons below district judge, person below district judge. So district judges are appointed by the governor in consultation with the High Court. Person below district judge are appointed by the governor in consultation with the High Court and State Public Service Commission, right? तो यहाँ पे C होगा ऑप्शन, आई थिंक. गवर्नर in accordance with consultation with the High Court and State Public Service Commission, right? So C is the answer. Consider the following statements. The trade, commerce and intercourse throughout the territory of India shall be free without any restrictions. Restrictions can be applied. तो either one will be true or two will be true. तो एक restriction बताता है, दूसरा बोलता है free है. तो first is false because it is not unrestricted. Parliament may by law impose the restrictions. On what ground? On the ground of public interest. If there is a scarcity of some goods in one portion of the particular state, so there can be restriction which is imposed upon them. This is true statement. Consider the following statement. No person who is a member of civil services of the union or all India services shall be diminished or removed by authority subordinate to that who has appointed him. This is true. This is the actual protection which is given to the constitution, which is given by the constitution to members of all India services or civil services, IAS, IPS log. It is not necessary to conduct the inquiry if such persons are dismissed by the president and he is satisfied that in the interest of national security of the state, in the interest of the security of the state, it is not expedient to hold such inquiry. True, right? So process ये करता है सबसे पहले, the person who has appointed persons below him should not dismiss him, right? And even if the person who has appointed him is going to dismiss, there should be an inquiry which has to be conducted, and in that inquiry, the person who is getting dismissed shall be given the opportunity. But there are certain constitutional exceptions also. If the president thinks that that inquiry will be detrimental to the security of the state, it is not required to conduct the inquiry. Both the statements here will be true. President is not. Is there any case where civil servants are appointed by a person other than the president? State civil services वाले गवर्नर अपॉइंट करता है. State civil services. Civil services does not include IAS, IPS. It includes other services also. Consider the following statements. If the Council of State has declared by a resolution supported by not less than 2/3 of the members present and voting, new All India services can be created by the government. आप statement सही से पढ़ो. A Council of State, if Council of State has declared by resolution supported by not less than 2/3 of the members present and voting, a new All India services can be created by the government. It can be created by Parliament. It can be created by Parliament. ऐसे ही फंसाएगा. The All India Judicial Services shall not include any post inferior to that of the judges as defined under. Shall not shall not include any post inferior to district judge as defined under 236. तो देखो ऑल इंडिया सर्विसेज क्रिएट की जा सकती है एंड दैट ऑल इंडिया सर्विस में ऑल्सो इंक्लूड ऑल इंडिया जुडिशियल सर्विसेज, बट हु इज गोइंग टू बी द पार्ट ऑफ ऑल इंडिया जुडिशियल सर्विसेज? दीज आर द पर्सन्स of and above the district judge. It will not include the persons below district judge. This is also mentioned very clearly in the constitution. This is a true statement, this is a false statement, because parliament by law can create, it is not the government order which can create. However, the first portion, that council of state has declared by a resolution of not less than 2/3, this much portion is true, but it cannot be created by the government, it can be created by the parliament. Under the Constitution of India, the power to extend functions of Union Public Service Commission has been vested in President of India, Parliament, Chairman of the Commission, Ministry of the Personnel. Parliament can, by law, it can extend. Which one of the following statement is correct? Union Public Service Commission may serve the need of the state if requested by the governor of the state and approved by the president. May serve the need of the state if requested by the chief minister of the state. ऐसे प्रोविजंस चीफ मिनिस्टर का बाय थियोरेटिकली तो नहीं आ सकते. It is possible by governor only. Union Public Service Commission cannot serve. This is false. Union Public Service Commission may serve the needs states by simply on the request of governor, and the approval of president is not necessary. This is false. A is correct. Which of the following statement is not correct? Expenses of union or state public service commission, including the salaries, allowances, shall be charged upon the consolidated fund of India. True है. It shall be the duty of the union commission to present annually, to present report annually to the president. True. President in his discretion may cause those reports to be led before each house of the parliament. In his discretion, or is it binding upon the president? It is binding. तो वर्ड यूज देयर इज शैल. डिस्क्रिशन का मतलब वो नहीं भी कर सकता. अच्छा, दो हिंट दिया है, एक डिस्क्रिशन है एंड मे भी है. सो वर्ड हियर इज शैल. प्रेसिडेंट शैल को ले बिफोर द रिपोर्ट टू बोथ हाउसेस ऑफ पार्लियामेंट, एंड ऑल्सो इफ देयर इज एनी एक्शन विच हैज नॉट बीन टेकन ऑन दोज रिपोर्ट, सो विद द मेमोरेंडम दैट व्हाई दोज एक्शंस हैज नॉट बीन टेकन. ये सेम प्रोविजन अप्लाई होगा नेशनल कमीशन ऑफ शेड्यूल कास्ट के रिपोर्ट के ऊपर, शेड्यूल ट्राइब के रिपोर्ट के ऊपर, राइट. सो कैग के रिपोर्ट के ऊपर. So this statement is not correct. प्रेसिडेंट का डिस्क्रिप्शन नहीं है, प्रेसिडेंट को पार्लियामेंट के सामने रखना ही रखना है. D says that chairman is not further eligible for appointment. This is true. 483 under Article 3. He is not eligible. When the person has been appointed as the chairman of UPSC, he is not eligible for further employment under government of a union or of the state. Right. Under Article 323A of the Constitution, a tribunal can be created for the following: levy, assessment, collection and enforcement of any tax, foreign exchange, import and exports across the custom frontiers, industrial and labor dispute, for disputes and complaints with respect to recruitment and conditions of service of persons appointed to the public service. D, right? D, this one. This is under 323A. बट अगर मैं सिंपली पूछता है ट्रिब्यूनल कैन बी क्रिएटेड फॉर विच, तो ऑल फॉर ऑल के लिए दीज ट्रिब्यूनल्स कैन बी क्रिएटेड, बट फॉर अंडर आर्टिकल 323B. एडमिनिस्ट्रेटिव इज वन. दिस वन इज 323A इज एडमिनिस्ट्रेटिव ट्रिब्यूनल. ट्रिब्यूनल फॉर अदर पर्पसेस 323B. बोथ दीज प्रोविजंस हैव बीन अगेन इंट्रोड्यूस्ड बाय 42nd अमेंडमेंट एक्ट. 484. Which one of the following are envisaged by right against exploitation in the Constitution of India? I think इस तरह का एक यूपीएससी ने भी पूछा है. नहीं, उन्होंने पूछा है हाँ, राइट टू एक्सप्लॉइटेशन का क्या क्या पार्ट है. प्रोहिबिशन ऑफ ट्रैफिक इन ह्यूमन बीइंग अगेंस्ट द फोर्स लेबर, abolition of untouchability, this is article 17, right to equality, protection of the interest of minorities, article 30, 29 and 30. 29 is for any section of the citizens. Prohibition of the employment of children in the factories, so this is there. 1 and 4, D. These are the two parts. So this is given under article 23, this is given under article 24. 485. As far as armed forces are concerned, the fundamental rights guaranteed under article 14 and 19 of the Constitution are not available at all. available to the armed forces but not to the other forces, available only at the discretion of Chief of Army Staff, available but only according to the law made by the Parliament. So Parliament has the power to restrict the fundamental rights by law of the members of armed forces. Armed forces does not include the only defense, it may include all the other forces have been given the duty of maintaining public order, right? So this is the D option is correct here. 486. Consider the following statement in the context of judicial system of India. The legislature is indirectly involved in the process of appointment of judges. The judiciary is not financially dependent on either executive or legislature. The actions and decisions of the judges are immune from personal criticism. Supreme Court and the High Court both are a court of record, but it is only the Supreme Court which has the power to punish for the contempt. Right? Let's see each statement. Legislature is indirectly involved. Neither directly nor indirectly, legislature is not involved in the appointment. In the removal, legislature is directly involved. So this statement is false. Judiciary is not financially dependent upon the executive or legislature. This is true. But they are charged upon, no? They are charged upon. Even if the Parliament want, it cannot reduce that. Right? So they are not a dependent. This is true statement. Actions and decision of judges are immune from personal criticism. This is true statement. Supreme Court and High Courts both are a court of record, but it is only Supreme Court. This will be a false because High Court also has the power, right? So 2 and 3 is correct. ये आपने जुडिशियरी वाला जो चैप्टर है एनसीईआरटी, वहां पे यू विल फाइंड दिस डिस्कशन. 487. Fundamental rights given under Article 19 can be claimed only against the actions of the state. It can be individual also. Abhi recent judgment of the Supreme Court went for the horizontal application of the fundamental right under 19. So now, as per the decision of the Supreme Court, Article 19 can be claimed against fellow citizens also, right? So this is false statement. The freedoms provided under Article 19 can be restricted on the reasonable grounds. Very easy. So this is true statement. On which of the following, which one of the following freedoms can be restricted upon the grounds of security of the state? Security of the state के ground पे इनमें से किन right को restrict किया जा सकता है? Which of these rights can be restricted on the grounds of security of the state? One is speech and expression, peaceful assembly, association of union, or right of movement. So security of the state as a word, it is mentioned under Article 19.2. Article 19.2. Sovereignty and integrity of India is different thing. That is applicable in first, second and third. वो आपको पहला A, B, C, 19 A, B, C और जितने भी राइट्स हैं 19.1A, 19.1A, B, 19.1C, इन तीनों में जो राइट दिए गए हैं वो सॉवरेनिटी एंड इंटीग्रिटी के ग्राउंड पे कर्टेल किया जा सकते हैं. बट सिक्योरिटी ऑफ द स्टेट के नाम पे फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन कर्टेल किया जा सकता है. राइट टू मूवमेंट के दो ही ग्राउंड है, इंटरेस्ट ऑफ द जनरल पब्लिक एंड इंटरेस्ट ऑफ द शेड्यूल्ड ट्राइब्स. राइट, राइट टू मूवमेंट को कर्टेल करने के लिए जो रेस्ट्रिक्शन है दैट इज सेम फॉर राइट टू सेटलमेंट. Which one of the following amendments added right to education as a specific fundamental right? This is very easy question. 86th amendment. Which one of the following is or are true about the recent reservation in higher educational institution and job provided to economically weaker section of the society through 103rd Amendment Act? 103rd Amendment Act के बारे में पूछ रहा है. The benefit can be availed by all economically weaker section of the society. It is false. There may be economically weaker section among SCs also, among STs also, but they cannot avail this 10% benefit. This is only applicable to those persons who belong to economically weaker section and already they are not giving any caste-based reservation, right? So this will be false. Constitution itself capped the reservation to 10%. Abhi we have seen. So this is true statement. 491. Consider the following statement. The term untouchability has not been used in Article 17 of the Constitution. False. The term untouchability has not been defined in the Constitution of India. It is true. Right under Article 17 is available against the state only and not against the private individual. This will be false. So 1 and 3 are the false statement. 2 only is the correct, right? So right untouchability has been abolished by Article 17, and its practice in any form is punishable. However, there is no law or no punishment which is provided in the Constitution. Constitution में कोई punishment नहीं दी गई है untouchability practice करने के लिए. तो कौन punish करता है? So there is Civil Rights Protection Act. Civil Rights Protection Act which punishes any form of untouchability. Untouchability करके क्या होता है? Religious disability की जा सकती है, social disability की जा सकती है. So all those kinds of disabilities which is arising out of untouchability is punishable under Civil Rights Protection Act, right? Then we have question 492. Which of the following is a fundamental right provided only to the citizen of India? Freedom of speech and expression, it is given under Article 19. Right against self-incrimination, this is given under Article 20, subclause 3. Equality before law, equal protection of law, this is given under 14. Right to be produced before nearest magistrate under Article 22. And what are those rights available only to the citizen? 15, 16, 19, 29 and 30. So by this, B is the obvious answer. Consider the following statements. The committee to appointment of election commissioner and chief election commissioner, अभी ये latest judgment of the Supreme Court के ऊपर based है, so this is quite contemporary thing. The committee to appointment of election commissioner and chief election commissioner consists of the prime minister, leader of opposition in the Lok Sabha, and 4 senior most judges of the Supreme Court. So this is the false statement. One is false because it shall consist of prime minister, leader of opposition in the Lok Sabha, and CJI, not 4 senior most judges. The post of leader of opposition was given statutory recognition in 1977. This is true. The election commissioner and the chief election commissioner of India enjoys same salary, privilege and security of tenure which has been given to a judge of Supreme Court. The election commissioner does not get the same. Chief election commissioner of India gets the same. So security of tenure is not applicable, not available to other election commissioner. It is available only to the chief election commissioner of India, not to the other. So this makes this statement false. 1 and 2 is correct. 494. Consider the following statements about Article 14 of the Constitution. It confers equality before law and equal protection of law on citizens only, aliens both. So this will be a false statement. The concept of equality before law in the Indian Constitution is of American origin and connotes to the equality of treatment under equal circumstances, both in privilege conferred and liabilities. It is rather equal protection of law. Equal protection of law is from the American origin. Equality before law is for the British origin. और ये जो नीचे definition लिखा है, it relates to equal protection of law, right? So this is false. Both the statements shall be false. Question 495. Consider the following statement. All authorities, civil and judicial, in the territory of India shall act in the aid of the Supreme Court. This is true. The minimum number of judges required to sit for the hearing of a case on which a reference has been made to the Supreme Court is 5. So President can refer, and that rule is given under Article 145. Supreme Court shall not pronounce any judgment without majority of judges on the bench concurring to it, and there is no provision of dissenting judgment under the Constitution of India. Dissenting judgment is also allowed, but it's that the court's opinion will be that of majority, right? So third one is false. First one is true. Second, true. So answer shall be. ये वाला है क्या? Only 2 statements are correct. So which one is correct? 1 and 2 is correct. So only 2 statements are correct. Consider the following statement with respect to powers of the governor of state. Governor can summon, prorogue and dissolve the state legislative assembly. It is true. Governor can adjourn the sitting of the state assembly. This is false. Adjournment, be it for the Lok Sabha, be it for the Rajya Sabha, it's the role of respective presiding officer, that is speaker or chairman. Governor addresses the first session of the legislative assembly after the election. This is true. The governor causes to lay the annual budget in the state. This is true. So 1, 3 and 4. B is the correct choice. Which one of the following statement is not correct about the MP lad scheme? Evergreen scheme hai. It's every time in the current affairs, but this is a very old scheme. It is a central government scheme under which MPs can recommend development programs involving expenditure of 5 crores every year in their respective constituencies. They can recommend. It is not that they will sanction the funds, and neither the funds are given to the MPs. Simply MPs will recommend, and that those funds will be directly transferred to the local authorities. Right? So first statement is however correct. Second says MP only from the Lok Sabha are eligible. This is false. MPs from both Lok Sabha and Rajya Sabha. The government transferred it directly to the respective local authorities. This is true, and it was launched in 1993. This is also true. 498. Which of the following statement is not correct about the Speaker of Lok Sabha? Speaker holds the office from the date of his or her election till immediately before the first meeting of Lok Sabha after the dissolution of one which he or she was elected. This is correct statement. So Speaker एक बार elect हो गया, and the Speaker has to be one of the members of the House. However, he will not resign immediately if the House is dissolved. He will wait till the fresh election is done and before the first sitting of the newly constituted Lok Sabha. He or she is eligible for re-election. Simply is a member. On the dissolution of the Lok Sabha, although the Speaker ceases to be a member of the House, he does not vacate his or her office. The Speaker may at any time resign by writing to the President of India, Deputy Speaker. So this one is false statement, rest other are true. Question number 499. Consider the following statement with regards to the Chief Minister of the state. He is appointed by the Governor. True statement. He and his Council of Ministers are collectively responsible to the Governor. This is false. To the Legislative Assembly. He must communicate to the Governor all the decisions of the Council of Ministers relating to administration of the state and proposals for legislation. This is true. If the Governor of the state so requires, Chief Minister shall submit for the reconsideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been collectively considered by the whole council. अगर कोई इंडिविजुअल मिनिस्टर का रिकमेंडेशन चीफ मिनिस्टर लेके पहुंच जाता है तो गवर्नर कैन से प्लीज गेट इट कंसिडर्ड बाय अदर मेंबर्स ऑफ द काउंसिल आल्सो. सो दिस इज ट्रू. व्हाट वी हैव टू फाइंड इज करेक्ट फाइंड करना है. सो सेकंड वन इज फॉल्स. 1, 3 एंड 4 इज द करेक्ट स्टेटमेंट. Now coming to the last of it, which one of the following statements regarding the exercise of judicial review is not correct? A case must be brought before the Supreme Court regarding the validity of law. Unanimous opinion of all judges is necessary for declaring law as null and void. Legislative enactment and executive may be struck down by the Supreme Court. The power is implicit in the provisions of Article 13 of the Constitution. B is incorrect. Unanimous opinion is not. Suppose it is the majority opinion. If there is a 7-judge bench, 4-3 will work, 5-2 will work, anything will work. So majority more than 3, that is 4. At least 4 judges should be in favor of any judgment or striking down any law. Right? So these are of the 500 questions we have covered. In today's questions, the emphasis more was on giving you a simple revision rather than covering in detail और कुछ टफ से क्वेश्चंस जानबूझ के नहीं डाला गया क्योंकि at this point of time I didn't want to confuse anyone. तो जितना ही पढ़ा है उसको रिवाइज करिए and after 10 days I hope you very best for your examination. All the best.